I want to talk a little about domestic abuse by answering some questions. Firstly, what does the court need to know to make a protection order? The court needs to be satisfied of three elements in order to be able to make a protection order. The court assesses the facts on the balance of probabilities, which means it's more likely than not that a certain event occurred. The court needs to be satisfied of the following. 1. That a relevant relationship exists. The other person is a former spouse, current spouse, family member, parent, child, etc. 2. That an act of domestic abuse has occurred. You can allege 10 acts of domestic abuse. The court simply has to be satisfied that one act is likely to have occurred. 3. That it is necessary or desirable for the court to make a final protection order. Secondly, what is domestic abuse? Section 8 of the Domestic and Family Violence Protection Act Queensland sets out what domestic abuse is. Domestic violence is behaviour that is physically or sexually abusive, emotionally or psychologically abusive, economically abusive, threatening, coercive, behaviour that in any other way controls or dominates the second person and causes the second person to fear for the second person's safety or well-being or that of somebody else. Without limiting the above, domestic violence includes the following behaviour: causing personal injury to a person or threatening to do so, coercing a person to engage in sexual activity or attempting to do so, damaging a person's property or threatening to do so, depriving a person of the person's liberty or threatening to do so, threatening a person with death or injury of the person, a child of the person or someone else, threatening to commit suicide or self-harm so as to torment, intimidate, or frighten the person to whom the behaviour is directed, causing or threatening to cause the death of or injury to an animal, whether or not the animal belongs to the person to whom the behaviour is directed, so as to control, dominate, or coerce the person, unauthorised surveillance of a person, unlawfully stalking a person, and a person who counsels or procures someone else to engage in behaviour that, if engaged in by the person, would be domestic violence, is taken to have committed domestic violence. I am often asked, what is coercive control, and is it domestic abuse? Coercive control is a pattern of assault, threats, intimidation, humiliation, and other abuse that ultimately erodes a person's autonomy and ability to thrive. And yes, it certainly is domestic abuse. Many survivors of domestic abuse describe coercive control as the most harmful aspect of their abusive relationship. Victims, who are mostly women, may be trapped in a relationship characterised by fear, manipulation for decades without any physical violence, but the torment is just as devastating. The murder of Hannah Clark and her 3 children in February 2020 by Hannah's estranged husband was the first physical violence in an otherwise long-term abusive relationship that was characterised by coercive control. This case, along with Jess Hill's book that came out in 2019 called See What You Made Me Do, greatly influenced the move to criminalise coercive control. The Queensland Government set up a task force in March 2021 to investigate coercive control. Many recommendations have been made, including coercive control being included in the criminal code, making changes to how the Queensland Police Service responds when a woman seeks help from police. On the flip side, what if you've been served with an application for a protection order? What should you do? It is important, if you are served by the police with an application for a protection order, that you seek legal advice immediately. If a temporary protection order has been made and you've been served with that, it is critical that you abide by the terms of that order, even if you don't agree with them. If you do not abide by the terms, you can be breached and charged with the contravention of a domestic violence order. The first time that you attend court, you will need to let the court know what you're doing. Are you consenting without admissions, wanting to contest the application, or wanting to adjourn, postpone, the matter to obtain legal advice? Is a domestic violence order, domestic abuse order, a criminal matter? No, it is a civil order and it is not a criminal order. However, if you breach the domestic violence order, including a temporary domestic violence order, and the breach is established in court and you were charged and convicted of a breach, then it's a criminal matter. How long does a protection order stay in place? The mandatory period for a protection order to stay in place is now 5 years. Protection orders can be varied. They can be shortened, but you must make an application to vary the protection order. The aggrieved or the respondent can apply to vary the order. The magistrate has to be satisfied that the variation will not be to the detriment of the aggrieved. If you're experiencing domestic abuse, there's a couple of things you can do. Link in with your local DV service and get some legal advice. If you're in Townsville, come and see us. We want to help you. If you're thinking about separating, or if you have any type of family law questions, it's always a good idea to come and get some advice from an experienced family lawyer that's specific to your situation. OSheaDyer offer first appointments with an experienced lawyer for a low fixed fee of $220. You get an hour with a lawyer who practices exclusively in family law, so you can figure out your next steps. Getting good advice from an experienced family lawyer can make all the difference to your future.